We are going to start now. The topic is the state of Tamil Nadu versus Governor of Tamil Nadu. The speaker is topmost senior advocate in constitutional law, Mr. Shekhar Naphade, is going to address on this topic. It is a recent judgment delivered by Justice V. Pardiwala and Justice R. Mahadevan. Sir, we are grateful to you. Immediately accepted. You are addressing our Friday group. So please address it.
Good afternoon to everyone. Today's topic is of great significance as far as the federal structure of our constitution is concerned. Before I take you to the details of the case, I must say a few things by way of introduction. Whenever there are different political parties in power, one in the center and the other in the state, there is a stress on federal structure. Now, the Supreme Court being the custodian of the Constitution has to play a role of an arbiter. Now, this matter involves the working of the federal structure of our government setup. The issue in short is this, that in state of Tamil Nadu we have DMK, which is in power, and in the center we have BJP. State of Tamil Nadu Legislative Assembly passed 12 bills. Those 12 bills were presented to the governor, and the governor did not grant the assent for a long time. And that led to the filing of a writ petition in the Supreme Court. And finally came the judgment. Now the judgment has very far-reaching implications. I'll just tell you a few relevant facts, then we can go to the relevant questions of law. Between 13th of January 2020 and 28th of January 23, Tamil Nadu Legislative Assembly passed 12 bills. No action was taken for a long time. The writ petition came to be filed in the Supreme Court on 31st of October 23. In that writ petition, court was pleased to issue notice on 13th of November 23. 10th of November 23. Immediately thereafter, on 13th of November 23, the governor became active. Out of those 12 bills, he reserved 2 bills for President's consideration, and 10 bills governor was pleased to return to the Legislative Assembly. The Legislative Assembly repassed those bills and presented them again to the governor. At that stage, the governor referred the bill to the President for consideration. Those 10 bills were referred by the governor to the President's consideration. In this light, the first question that arose was whether governor was justified in not granting assent after the bills were represented to him. That's point number one. The second point was whether after the bills are represented by the Legislative Assembly, whether Governor has jurisdiction to refer the bills to the President for his consideration. These were the two important issues. Now, I will show you what were the prayers in that writ petition. The prayers are in paragraph 2 of the judgment of the court, and I will just quickly read those prayers. We cannot understand the real import of a judgment unless we see the factual matrix from which the judgment arises. These were the prayers. Withholding of assent to and reserving for consideration of the President by the Governor of 10 bills enacted by the list is ultra-vires. Inaction on files, etc., etc. So therefore, the principal question was this, and whether reservation of reference of those two bills to the President was warranted or not. These were the issues. Now I will briefly indicate to you what were the submissions that the state of Tamil Nadu made before the court. Number one, that Article 200 gives Governor only three options. Number one, once the bill is passed and presented to him, he can grant assent. If the Governor is pleased to grant assent, the matter comes to an end, it becomes a law. You are all aware that a bill passed by a Legislative Assembly does not become a law unless it receives the assent of the Governor, and in case of Parliament, it receives the assent of the President. What are the three options to him? One, that he grants assent, then the matter comes to an end. The second is that he withholds the assent. And the third is that he reserves it for President's consideration. Now this second option, that he withholds the assent, is the main fulcrum or the main point in controversy in the matter. The contention of Tamil Nadu was that his power to withhold the assent carries with it an obligation to return the bill to the Assembly. Have I made myself clear? In other words, he cannot simply withhold the consent. We are not dealing with the third option of referring it to the President. As far as those 10 bills are concerned, we are concerned with the situation where he returned the bill. Now the contention of the Union of India was that there are four options. Now see the point of controversy. I restate the Tamil Nadu proposition that there are three options and not four. Union of India or the Governor's was there are four options. We will examine them so that the controversy comes in a focus. One, he assents the bill, matter ends. Second, he withholds the assent. Now the contention of Tamil Nadu is that if he is not referring to the President for his consideration, then that withholding is coupled with an obligation cast upon him under the proviso to Article 200 that he must send it back with reasons. Two propositions. That there is an obligation to send it back to the Assembly if he is not referring to the President. Second, that return with reasons. You can't simply return. These were the two propositions. And the contention of the governor was that 4 options. Grant the assent. Second, withhold the assent. Third, refer it to the president. And the fourth, which he may return it to the assembly for reconsideration. So this was the controversy in focus. Now let me, since I have stated the precise controversy in the issue, let me tell you what the further contentions of Tamil Nadu are. First, that simply withholding amounts to a pocket veto. What is pocket veto? It's a concept which is not known to the Indian constitutional law. It's an American thing. The pocket veto means that whenever the legislative body in America, which consists of Senate and the Congress, they pass a bill presented to the President for his assent, the President simply puts it in his pocket. And when the Legislative Assembly session stands adjourned, the bill automatically lapses. This is not the position in India. A bill which is passed never lapses. The classic case, anybody can tell me which is the classic case where there was a tussle between the President and the Prime Minister? Anybody remembers that case? Yes?
Jani Singh was the president.
Yes, but which is that bill? The Postal Amendment Bill, right? That bill remained pending for 12 years. Anyway, the point now is that whether the President or the Governor has a pocket veto, the answer given by the court is no. The second contention is that while returning the bill to the Assembly, you must give a reason. Without reason, you cannot return the bill. The next proposition was that once the Governor came to the conclusion, and in his report, when he referred the 10 bills after they were repassed and represented, he stated in the report to the President that the bills are intra vires. In other words, what the learned Governor said was that these are bills which related to educational matters, some matters related to university, some matters relating to appointment of Vice Chancellor, etc., etc. And as far as university affairs are concerned, it's a matter which falls under entry 32 of the list 2, which is the state list. And other educational matters were concerned, they were covered by entry 25 of the list 3. There is one entry in the list 1, that is entry 66 of list 1, which is exclusively under the domain of the Parliament, which relates to a professional competence, etc. In other words, dealing with higher standards of professionalism. Now the Governor, having said in his report that the bills were intra vires, therefore he had no jurisdiction to refer the matter to the President. So that is one aspect. Then the withholding was without any time frame is illegal. The next contention was that the Governor's action of withholding or referring to the President is subject to judicial review. Even though it's a constitutional function, it is subject to judicial review, and the reliance was placed on S.R. Bomai's case, 1994, 3 SCC, page 1, Rameshwar Prasad versus Union of India, and Kyoto, 1992 supplement is 2 SCC page 651. In all these three judgments, there is a common thread. Bomai deals with exercise of power under Article 356, that to dismiss the state government on account of its affairs are not being carried out in accordance with the Constitution. Rameshwar Prasad and Kyoto deal with defection. Rameshwar Prasad also deals with who should be invited to form a government in case there is a split verdict. So all the three judgments deal with the exercise of constitutional powers. And Apex Court came to the conclusion that notwithstanding the fact that the governor or the president is exercising in case of disqualification, it is the speaker. Even though they are discharging constitutional powers and functions, it is still subject to judicial review. So reliance was placed on that. Then, that the governor, while acting under Article 200, has to act on the aid and advice of the Council of Ministers. Reliance was placed on Article 163 and two judgments, Shamsher Singh versus State of Punjab, 1974, 2 SCC, page 831, S.R. Bomai, and that Arunachal Assembly case, famous 2016, volume 8 SCC, page 1. Then the next contention was that look at the constitutional history of Article 200. For our immediate reference is the Government of India Act 1935. Our constitution largely is modelled on Government of India Act 1935, except the fundamental rights which have come for the first time as a constitutional document. Now the corresponding section in the Government of India Act was section 75. And the argument was that there is a marked distinction between section 75 and Article 200. Section 75 in categorically terms laid down that the governor in his discretion may refer the bill to the Governor General, or the governor in his discretion withhold the assent. These words are missing in Article 200. So the argument was that the framers of the Constitution have consciously refrained from making a provision of government in his discretion. That was one of the contentions which was. Then a great reliance was placed on the debates on the Constituent Assembly. How this Article 200, its draft article, what were the changes, and one of the things which was discussed in the Constituent Assembly was Section 75 of the Government of India Act 1935, and how members expressed a view that we should not adopt that method of conferring a discretionary power on the governor. So that Constituent Assembly debates were considered by the court and also by the Tamil Nadu. Then I just want to add here a rider. See, if you see all important constitutional law pronouncements by this court, they are largely followed the debates in the Constituent Assembly. Now, whether debates in the Constituent Assembly should be considered or not is a debatable issue itself. But I don't propose to go into that issue at this stage. But there is one exception. If you see the debates in the Constituent Assembly with regard to the appointment of High Court judges and the Supreme Court judges, the debates clearly indicate that it is the prerogative of the President in consultation with High Court judges and the Collegium or the Chief Justice, and in case of High Court also the same procedure. In other words, the Constituent Assembly debates clearly indicated that the initiative is with the executive. But the catena of three judgments laid down by this court, they have said no, it is the collegium. So that is, in other words, the initiative comes from the collegium in case of Supreme Court judges, 1+2, Chief Justice and 2 judges, 1+4, and in case of appointment of a High Court judge, 1+2 of the Supreme Court judges. Anyway, now the second point was, the next point was that if the governor wants to reserve the bill for President's consideration on the ground that there is a repugnancy between the law passed by the state legislature and the existing central law. If that is the ground, then the governor cannot simply say that there is repugnancy. There is an obligation on the governor to identify the central law. Second requirement, that what is the nature of repugnancy also must be specified. In other words, it must be a reasoned reference and not ipse dixit of the government. So in other words, when you are discharging a constitutional function, your action must be informed by reason. That is one of the contentions which was. And the most important contention was that the governor is bound by aid and advice, except in certain extraordinary situations. And the judgment, as I told you, state of that Shamsher Singh versus State of Punjab, etc., etc. Now, question of time limit came. That once the bill is presented, within what time the governor should either assent, withhold, refer, etc. The argument of the state of Tamil Nadu was that there is one material word used, as soon as possible. If you look at Article 200, there is that one word, that when a bill is presented, as soon as possible. Now that indicates, these words indicate that the constitution makers contemplate a definite time frame. If you do not take a decision within a reasonable time, it will amount to a pocket veto, as it happened in that postal bill. But at postal bill precedent withholding, nobody challenged it. It would have been embarrassing for the government itself. So this time limit is required, and the question arose whether the court can prescribe a time limit. Now these were broadly the submissions of the state of Tamil Nadu, and of course they also relied upon Sarkaria Commission reports and several commission reports that the governors must act reasonably within a reasonable time frame. All those reports, etc., were shown. Now, before I take you to the conclusions, after setting out the conclusions of the court, I may have to say something on the judgment, which may not be possible today because of the constraint of time, because the judgment is of a far-reaching consequence. And I will briefly indicate to you that how many articles this judgment will have impact on how many articles. Number one, first Article 145. I have my doubts whether this could have been decided by a two-judge bench. If you look at Article 145, Clause 3, any question, substantial question of law as to the interpretation of the Constitution must be decided by a bench of not less than 5 honorable judges. That is Constitution bench. This is one aspect. The other articles are Article 14. I forgot to tell you that one of the grounds which Tamil Nadu urged was that governor withholding the assent for a long time is arbitrary, and therefore Article 14. And you are all aware that after E.P. Royappa's case, arbitrariness is also a facet of Article 14. So Article 14 was pressed into service. Then Articles 31A, Article 31C. These articles have a direct impact on the legislative powers of the state assemblies. Even if the subject matter is within their legislative competence, anything which touches these articles, 31A which deals with property rights, 31C which deals with the directive principles of the state policy, that is any state legislation which purports to give effect to the directive principles of the state and is in conflict with any of the fundamental rights, then it requires a prior clearance of the precedent. So it has impact on Article 31A, 31C, Article 163, 145 already indicated to you. 163 deals with there shall be a council of ministers to aid and advise the governor, except in cases where he has to act in his own discretion. So 163 is also involved. Then 168, Article 168 is of great importance because it says, and we often lose sight of the fact, that governor is a part of legislative body. The legislative assembly of a state consists of elected members and also the governor. So what is the role of the governor as being a part of the legislative assembly under Article 168? Unfortunately, this point was not debated in this case. Anyway, then Article 196 to 201 will directly deal with the bill, passing of the bill and the governor's assent. Then Article 246 and 254 which deal with distribution of legislative power and will therefore directly impact on the reservation of a bill for President's consideration. Then Article 288, 301, 33, 356, 360, 364, Schedule 5 and Schedule 6 also deal with certain aspects of the matter where the state legislation may have limitations. This is important from the standpoint of on what considerations the governor can refer a matter to the President, even though it may appear to be within the legislative competence of the state legislature. Then certain important principles, the basic principles of parliamentary democracy, then basic principles of constitutional law, then basic principles of a relationship between a constitutional head and a legislative body, and the concept of a federal structure. But apart from that, in this judgment you will find that the court was pleased to observe that certain judgments are per incuriam. For example, a judgment of two learned judges in Valuri Basavaiya Chaudhary. Two learned judges delivered that judgment, and the present judgment is of two learned judges, And the two learned judges in this case have chosen to describe the observations in Valuri's case as per incurium, whether it is permissible. This also involves a question whether what is a ratio, what is an arbiter, what is per incurium, what is a casual observation, because several judgments were cited in this case and some judgments were considered argued as sub silentio, some judgments were argued as per incurium, in some cases observations were considered as arbiter, some cases were considered as casual observation. So when we study this judgment, we need to be clear jurisprudentially as to what is a ratio, what is an arbiter, what is a casual observation, and what Justice Fazal Ali calls as pondering in depth or an issue is not a judgment. You may deliver a learned treatise on something, the issue does not arise in that matter. Is it of any consequence? The distinction between these three concepts, ratio, arbiter and casual observation, is graphically described in one Bombay judgment, and I don't think anybody has attempted to improve upon it. It's a judgment of Justice Chagla, reported in AIR 1955 Bombay, page 113, where his lordship says that a ratio means the judgment of a court or the finding of a court on an issue which arises before the court. And not only that, it arises before the court, but it is necessary to decide that issue for the purpose of final disposal of the case. Now in this case, what was the issue? Whether upon representation of the bills, the governor was justified in referring to the precedent. That was the issue. The second issue was whether there is a fourth option. Anything else, would it perhaps may not fall? Time frame, etc., etc. Anyway, the second aspect is what is an arbiter. The judgment of Justice Chagla says that in case of an arbiter also, an issue arises, but in order to finally dispose of the case, it is not necessary to decide. And yet the court decides it's an arbiter. And what is casual observation? That the issue does not arise. It is not necessary to decide it. The court just says something. Even if it runs into pages after pages, it is still casual observation. Or we can put it in the better words of Justice Fazal Ali as pondering in depth or an issue is not a judgment for the purpose of Article 141. So these are the parameters by which we will have to assess the impact of the judgment on the articles of the Constitution, which I indicated to you, the federal structure of the Constitution, the power of judicial review of this court. Now let me take you to the findings which the court has recorded. And on the next occasion, whenever the time permits, I will respond to or rather my assessment of the judgment in the light of what I have indicated to you. Now let us see what issues the court had framed. Court broadly framed 6 issues. 1. What is the course of action that is available to the governor under Article 200? Which means 3 options or 4 options, which I indicated to you earlier. Next, whether reservation for precedent after the bill is represented, is it permissible? Third, what is the time limit within which the governor should act? Fourth, whether in all such matters the governor is bound to act on the aid and advice of the Council of Ministers. Next, whether the exercise of power by the governor under Article 200 or by the President under Article 201 is subject to judicial review. And what is the manner in which the President exercises powers under Article 201? These were broadly the main issues which the court had framed. I will briefly indicate to you what are the findings of the court. One, that this question whether the governor has a fourth option, which I indicated to you, this issue is no longer res integra in view of the Supreme Court judgment in State of Punjab versus the Governor, 2024, Volume 1, SCC, page 384. Now, this was the judgment which was subject matter of the Governor's contention that this judgment suffers from sub silentio. So, you saw the importance of this concept of what is sub silentio, what is per incurium. Second finding is that there is no pocket veto. What does that mean? That governor can't simply keep the bill on his table without taking any action. In other words, withholding does not mean denial. If you see even the dictionary meaning of withholding, withholding does not mean extinguishment. It means temporarily, or put it in the language of Supreme Court lawyers, pass over. It is passed over for some time. That would be a better way of understanding. Now, once the bill is returned to the assembly by the governor and the bill is repassed and presented to the governor again, then governor has no jurisdiction to refer it to the president for president's consideration. Most important finding is, which I have grave reservations about this finding, the court says that the governor's action lacks bona fides. Whether governor is also a constitutional functionary, just as Supreme Court is a constitutional body, the judicial restraint, if I may put it this way, I am not saying that court, but judicial restraint, whether the court should have passed such a remark. Then the finding on time, that you cannot keep the matter pending for a long time. I will briefly indicate to you what is the time frame that the court has laid down. This is a matter of this is going to be a contentious issue. What is reasonable time frame? Instead of indicating the parameters, the court has laid down the time frame. Then the court has accepted the contention that under the Government of India Act, Section 75 was in the discretion of the governor. Since that is omitted consciously after a debate in the Constituent Assembly, and Article 200 does not deploy that expression, there is no discretion with the governor. Then the exercise of power is subject to judicial review. And then comes the concept of a deemed consent. They have exercised power under Article 142. And though there is no consent granted, the court has declared in exercise power under 142 that all these 12 bills are deemed to have been consented by the governor or the president, as the case may be. This is broadly. Now, one more judgment which they have declared as per incurium is Pavitra. I am just indicating to you the important judgments. One is that Valori Chaudhary, the other is Pavitra 2019 16 SCC 129. These judgments are declared as per incurium. And in the case of Hodges Pharmaceutical versus State of Bihar, 1983 4 SCC, page 45, the court has only said, because this judgment is on the same lines as Valori, etc., but the court has said, court has not declared that judgment as per incurium, but the court has indicated that the principal content therein cannot be stretched too far. What those judgments are, we'll take up. Now, what their lordships have further done, which I will indicate to you, first the time frame. If you come to the page 393 of that judgment, I will indicate to you what is the time frame. In case of either withholding of assent or reservation of the bill for the consideration of the President upon the aid and advice of the Council of Ministers, the Governor is expected to take such an action forthwith, subject to a maximum period of 1 month. In other words, where there is an advice by the Council of Ministers to refer it to the President, the Governor should do so within 1 month. Second, in case of withholding of assent, contrary to the advice of the State of Council of Ministers, the Governor must return the bill together with a message within a maximum period of 3 months. So, after withholding the assent, within 3 months, he must return it to the Assembly. In case of reservation of bill for the consideration of President, contrary to the aid and advice of the Council of Ministers, the Governor shall make such reservation within a maximum period of 3 months. In case of presentation of a bill after reconsideration in accordance with the first proviso, the Governor must grant assent forthwith, subject to a maximum period of 1 month. In other words, once the bill is represented to the Governor, after it is passed by the Assembly again, then the Governor has no option but to grant his assent. And in this case, since the bills were repassed and represented to the Governor, their Lordship said that there is a deemed consent. This is how the matter stood. Now, therefore, let me summarize what the court has said. That the court has said there are only 3 options once the bill is passed. 1, grants the assent, then the matter comes to an end. Second, he withholds the assent, but it's not a pocket veto. That after withholding the assent, there is an obligation on the Governor to send it back to the Assembly. And if the Assembly repasses it, then, and represented the bill to the Governor, then the Governor has no option but to grant assent. The third option is that he reserves it for the President consideration. Then the matter goes to the President under Article 201. Now, there also now, for President also, the court has framed a time frame. Now, the issue before the court was only in the respect of the Governor's action. What the President is supposed to do was not the subject matter of the debate before the court. But the court has indicated. Now there is one more aspect which I feel the court has done in its advisory jurisdiction, and which I will indicate to you, that whenever the governor withholds the assent, the court has indicated the grounds on which such withholding can be challenged. This, in my respectful submission, is an advisory jurisdiction. And when President withholds the assent, then what should be the ground? Those also the grounds the judgment contains. This, in my respectful submission, seems to be beyond the scope of the matter that was before the court. Now, as I indicated to you, that we will have to consider number one, Article 145. Whether this could have been decided, just somebody would read out the text of Article 145.3.
Rule of the court, etc.
The rule-making power, 145 deals with it, but clause 3 is a fetter on court's power of framing rules.
The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution, or for the purpose of hearing any reference under Article 143, shall be 5.
Now, is it or is it not a question involving a substantive question of law as to the interpretation of the Constitution?
Yes.
That is point one. Next.
The
No, I am indicating. Next. Whether a bench of 2 judges can declare the observations made by coordinate bench as per incurium or sub silentio. This is the second issue. The third, what is the test by which you judge a observation as per incurium or sub silentio? Next, whether a time frame, a fixed time frame can be prescribed by the court while exercising its powers. Now, these are some fundamental issues with reference to which we will have to consider this case. Now, what is its impact on other articles? The list of those articles are already given to you. There are several such articles in the Constitution which I have indicated have some relationship with the state legislative assembly's power to make laws. Now, therefore, requirement that the governor must give reasons for referring a matter to the president. This requirement can't be confined only to repugnancy. It touches the other articles also which I indicated to you. So therefore, such a huge impact on the working of the Constitution is something which has a bearing on Article 145.3, Clause 3. So some of these issues are of grave importance. Now another which is important aspect is the judgment runs into 414 pages. Now, out of that, a substantial portion is the concept of assent, how it evolved, then debates in the Constituent Assembly. This discussion consumes nearly 200 pages. Now reading this judgment, therefore, sometimes we may have a difficulty in finding out what is the ratio of the judgment. So these are some important aspects which we will have to consider. I am still trying to attempt to analyze the judgment. It will take some time. So maybe on some next occasion we will take up this. But broadly I have indicated to you what was the controversy before the court and what is in substance is the finding of the court. If any questions, please ask.
You have enlightened us on lots of topics in this case. But, is this a case of a classical example of American legal realism, where we study as a student of law and jurisprudence, we study that when the judges can make law, when there is some lacuna or some vacuum is there in a legislative field, and it's in the interest of the justice, the judges comes in the shoes of the steps of the legislature. So by analyzing this your lecture, just I can see that it might be one kind of American legal realism in a jurisprudential concept.
See, my reaction is that it is difficult to borrow concepts from foreign lands and try to implant them, plant them in our constitutional soil. The American Constitution, its evolution, its interpretation by the court has its own ethos. Now our principal question is that is this a federal constitution or is it a quasi-federal? Now the governor being a part of the legislative assembly is something unique. And the governor also being the authority to grant assent to the bill. These are matters of grave importance. There are no parallels either from the American Constitution law or anywhere else. Now I'll give you an example. You need to amend the Constitution. Okay. Majority is not enough. You need 2/3 majority in both houses. In other words, a minority can play a role in defeating a constitutional amendment. Correct? Now the question which I ask myself, if the Constitution has given a primacy, I am not saying I subscribe to that view, but a possible contention that if by making a governor a part of the Legislative Assembly under Article 168 and giving him the power to grant or not to grant a consent to a bill, is it not something which is giving primacy to him? So these are, according to me, these require more adequate and in-depth consideration.
Do you want to continue, sir?
Somebody is asking something.
One more. Thank you very much, sir. Excellently explained this. We are all worried what exactly the correct, who is right, who is wrong. You enlighten in such a way.